all been looking at the implications for human rights and the rule of law of the COVID-19 pandemic. And I think many of us are sort of trying to raise awareness, I think, of the less obvious challenges that are posed by the pandemic and the responses thereto. Now, some of you will be aware of the history of the Human Rights Law Centre, but I thought I'd just give you a bit of background before we begin. So it was established in 1993 by Professor David Harris, who was looking at conducting research into human rights and the rule of law in post-Soviet Russia, and also providing training to law enforcement and judicial officers in these territories. Now, the centre has grown and developed since then, and it has a truly global reach. It's now a well-recognised focal point for research on human rights law and a space for research on new and existing challenges to the realisation of human rights. And we're always sharing this research. So we're always doing training and capacity building for governments, the judiciary, and civil society around the world, as well as making sure that our students at the university get to see our work. Now, today, the wonder that is internet communication means that we can bring together 3 expert members of the centre to talk about some of the wide-ranging human rights issues from COVID-19 and the responses to the global pandemic. But before we get there, I'd like to just mention a few housekeeping matters. Could I ask, if you're not already muted, that you mute your microphones. What we're going to do in terms of the structure of this seminar is we will first hear from our speakers, and then I will invite them to respond to questions and comments that you, the audience, have posed. So if you have any questions or comments related to their presentations, then please write them in the chat box, and I will present them to our experts. We're hoping that this is the most practical way of presenting your thoughts and questions to the speakers. Now, finally, I should say this webinar is being recorded. We hope that it will form a springboard for further work and discussion amongst wider society, and so please be aware of this as we go along. Okay, so enough introduction. I think perhaps we need to get going. So I'm going to turn to our first speaker, who is Professor Marko Milanovic. Marko is Professor of Public International Law at the University of Nottingham. And most of us will know Marko from his work on EJIL Talk, the blog of the European Journal of International Law, of which he is co-editor. He's also on the EJIL's editorial board and was formerly Vice President and member of the Executive Board of the European Society of International Law. Now, Marko is going to talk to us about the issue of misinformation. So we've all seen stories that have circulated on the internet and elsewhere suggesting, for example, that there's a link between 5G masts and COVID-19. Or you may have even heard the rumour that COVID-19 was developed in a laboratory by Bill Gates 5 years ago. Now, I don't think Marko is going to be spreading any misinformation himself, but he is going to introduce us to what human rights law has to say about combating such misinformation. So, over to you, Marko.
Thank you very much, Sangeeta. It's a really great pleasure to start this off. Welcome, everyone. I'm very happy to be with you today. I will be talking about the question of how international human rights law deals with misinformation or disinformation regarding the COVID-19 pandemic. I will tend to use the term misinformation only as a sort of catch-all generic term that captures any kind of spreading of information that is objectively false and that has something to do with the pandemic. The term disinformation is also commonly used, but that implies a certain kind of malicious intent, an intention to mislead. And while that is a very relevant consideration, I will leave it aside for a moment and we'll come back to it as we sort of discuss some of the substantive issues. So the legal question I really want to look at is, what does international human rights law have to say about the spread of misinformation, especially online, with regard to the COVID-19 pandemic? Now, as Sangeeta was saying, there is an enormous amount of misinformation about COVID that is being spread. Ofcom made the estimate that in 1 week in April last month, more than 50% of the British public were exposed to at least some kind of COVID-19 related misinformation. So the spread of misinformation is so pervasive that the World Health Organization actually said that in parallel to the COVID-19 pandemic, we have an ongoing infodemic with regard to various falsities about the virus and about treatments of the virus and so on. When it comes to the actual substantive variety of the misinformation that is being spread, that can range from minimizing the danger of the virus to promoting false cures, whether that's injecting bleach or drinking methanol, to conspiracy theories about the origins of the virus, its relationship to 5G, etc., etc., etc. So there's an enormous amount of variety when it comes to the type of misinformation that is being spread. The key issue for us, however, is who is doing the spreading. And here we need to distinguish between misinformation that is being spread by state actors on the one hand and by non-state actors on the other. The reason why this distinction is important is because international law and international human rights law in particular is mainly addressed to the conduct of state actors. So my main topic of inquiry is what are the obligations that are incumbent on states when they either spread misinformation or with regard to misinformation being spread by non-state actors. Now, in order to be effective, for that to actually work, misinformation must be spread on a significant, large-scale basis by innocent individuals who are doing it out of altruism. They're not doing it maliciously. That's how misinformation actually works. But state actors can either originate the misinformation or they can amplify misinformation that originally developed organically within a certain community. So, for example, there have been indications that various state actors have amplified 5G misinformation that originally simply arose spontaneously within the community. So we need to therefore distinguish between the various types of obligations that states have under international human rights law with regard to specific human rights, and we then need to examine how these various obligations apply to misinformation being spread either by state actors or by non-state actors. The human rights I will focus on primarily are the freedom of expression, the right to life, and the right to health. These are all protected, as you all know, in a variety of binding treaties, and also are formed part, at least to some extent, of customary international law. You will also know that human rights law imposes various sort of overarching structural obligations on states. The first primary obligation is the negative obligation to respect human rights, meaning to refrain from engaging without sufficient justification in activities that may adversely affect the human rights of individuals. The second obligation that is of relevance to us is the positive duty to protect individuals from harm, from actions by third parties that can be non-state actors or third states that might adversely affect individual rights. So I will look at both of these types of obligations. So let's start off first with the negative duty to refrain. So we have witnessed many state actors spreading misinformation for various motives, which may range from, preserving the authority of the regime, projecting a sense of competence, minimizing economic harms, etc., etc., etc. But we have witnessed state actors spreading misinformation which can have grievous consequences for public health. One example, for instance, is the conduct of President Trump in the United States, President Bolsonaro in Brazil, who have actively tried to minimize the impact of the pandemic within their countries, sometimes questioning the whole virulence of the disease, questioning the numbers of people affected, and so on. We have also witnessed state actors promoting misinformation with regard to particular remedies or treatments. So President Trump, for example, has not only suggested injecting a bit of bleach and ultraviolet light into one's veins, without explaining how exactly that would be done.
Thank you very much.
But he has also promoted very actively and continues to do so the use of hydroxychloroquine, an antimalarial drug, which has not been proven to actually work to address COVID, but does have proven side effects, especially for people who have some kind of a prior cardiovascular condition. The president of Madagascar, for example, has been promoting a particular herbal remedy and is forcing the population to use that particular remedy. So, for example, all children are required by the state to actually use that remedy today in Madagascar, and he's been peddling it in neighboring states in Africa. So that type of misinformation, which is peddled by the state, where there is a serious risk that that type of misinformation can affect adversely the health and life of individuals, is with a sufficient proof of causal connection, certainly capable of violating the human right to life and the human right to health. The issue with regard to the right to life is difficult because normally we say that in the negative aspect, the right to life is violated through a deprivation of life. And it is difficult to see, for example, how exactly the spread of misinformation alone could constitute deprivation of life. But so long as the link is causally strong enough, think, for example, in Iran, people dying from ingesting methanol, thinking that methanol would cure the virus. If you can prove that the state actor is spreading that type of misinformation, that is certainly not congruent with the negative obligation to respect life, and is beyond any doubt not congruent with the negative obligation to respect the right to health. And in fact, if you look at the Committee on Economic, Social, Cultural Rights general comment on the right to health, you will see that they talk about misrepresenting health information as a violation of the right to health. One could also argue that this spread of this type of misinformation is a violation of the aspect of the freedom of expression which allows individuals to seek and receive information that they want to receive, because the polluting of the information space makes that type of obligation impossible, that type of right impossible to fulfill. When it comes to the positive duty to protect, I would argue that when it comes to some specific misinformation being spread by non-state actors or third parties, the state has to actively, on the one hand, suppress that type of misinformation, and on the other hand, promote accurate information that will help the public deal with the pandemic. And states have certainly not been equally successful on the promotion of accurate information issue. Now, finally, if they do take measures to combat misinformation being spread by non-state actors, they must do so within the limits imposed by international human rights law, and they must not unduly infringe on the freedom of expression in particular. And one very concerning development over the past few months has been the use of older laws or the creation of new laws, specifically criminal laws, that penalize members of the public for spreading misinformation. Some of these laws are very vaguely phrased. They do not specify concrete harms that misinformation is causing, and they do not impose clear or high enough mens rea requirements so that these criminal laws are being effectively used by the state to silence criticism, to silence political dissent. And that type of legislation, which is being used now, in many parts of the world, is especially dangerous from a freedom of expression perspective, especially because the freedom of expression is actually essential to effectively combating the pandemic. You will all be aware how the initial stage of the pandemic, it was in fact the censorship by local authorities in Wuhan of whistleblower doctors who were trying to inform the public of the dangers of the new virus that actually allowed the epidemic to spread the way it did. So that is sort of my presentation in a nutshell. We see how the various different obligations imposed by states on states by international human rights law have a direct bearing on how they must combat the pandemic. Thank you so much.
Okay, thank you, Marco. That was fantastic. And I'm not even going to comment. I think the best way forward is just to move swiftly on so that we've got lots of time for questions and comments. Please do put your comments in the chat box, and I will be presenting them. So moving on, our next speaker is Professor Aoife Nolan. Aoife is co-director of the Human Rights Law Centre at the University of Nottingham, and she's Professor of International Human Rights Law. Since 2017, she has been a member of the European Committee of Social Rights, and she's acted as an expert advisor to a wide range of international and national organisations and bodies working on human rights issues. She is an academic panel member of Doughty Street Chambers, where she co-leads the Children's Rights Group. Now, Aoife is going to talk to us about responding to human rights violations arising from COVID-19 through litigation. And it's clear that we need to stop or prevent further human rights violations as the responses develop. And Aoife is going to discuss the global efforts to use litigation as a tool of accountability. So I'll hand straight over, if I can.
Thank you very much, Sangeeta. Perfect, I think, yeah. Okay, well, I'll begin. So, thank you very much for that, Sangeeta, and for that excellent presentation, Marco. I'm following on now, and I'm going to talk on, I suppose, a cross-thematic issue that is of great relevance in the COVID-19 context, domestically, comparatively, and eventually, I think, internationally. And that's the topic of strategic litigation, and specifically human rights related strategic litigation that's being brought in reaction to COVID-19 and state responses to COVID-19. Okay. And notably, I mean, it's trite at this point to flag. Everyone who's part of this seminar will be aware that there has been an explosion in this litigation. Okay. But very strong questions remain about the extent to which law and litigation will ultimately prove to be a key tool for human rights accountability in the COVID-19 context. So we know this litigation is being brought, but we're not clear yet. It's early days as to the extent to which law and litigation will play a role in terms of ensuring accountability of state authorities, non-state actors, etc., etc. Now, so I'm not going to try to come to definite conclusions in my presentation. Rather, I want to do three things. First of all, I'm going to outline some of the key patterns in global human rights related COVID-19 litigation as it stands, okay? Quick and dirty. Second, I'm going to talk about some of the challenges that are faced by those bringing litigation. And finally, I'll finish with a very brief statement or set of thoughts on human rights strategic litigation in a time of crisis. So, what do we see in terms of strategic litigation? Well, you know, you can categorize these of the existing cases in a wide range of different ways. So in terms of, as I said, my quick and dirty effort here this morning, I'm going to start by talking about those cases that are focused on the impacts of lockdown or shelter at home arrangements on the exercise of human rights. Okay, so the first category we see are, for instance, the cases dealt with by the German Federal Constitutional Court dealing with the impact of lockdown on political rights or the right to freedom of religion, the manifestation of and practice and exercise of the right to freedom of religion. And we see, I cite the German court here, but these cases have been brought in many different situations, particularly in the US, in the context of the anti-lockdown movement in recent weeks. The second area I want to flag are litigation efforts that are focused on trying to ensure the government does what's necessary to ensure people have access to what they need during lockdown, and indeed in the context of COVID-19 more generally. Consistent with the fact that many of the impacts of COVID-19 and lockdown are socioeconomic, it's not surprising that many of these cases focus on things like access to food, access to education, social security and assistance at a time when people simply aren't working and aren't allowed to work. In Nepal, we see the Supreme Court make an interim order requiring government to provide food to vulnerable workers during the lockdown period. In Malawi, we see the High Court going so far as to suspend the lockdown in that country on the basis that the government hadn't made adequate provision to help those worst affected and to give effect to their constitutional rights. And at the moment, that case is being appealed to the Constitutional Court. We also see litigation closer to home for those of us who are in the UK being planned in relation to the impact of school closures on children without adequate hardware or Wi-Fi so as to enable online learning. The third category I want to talk about very briefly is that of healthcare-related challenges. For instance, Adala, an organisation that some of you will know, the Legal Centre for Arab Minority Rights in Israel, very much focusing on the healthcare challenges faced by those it works for, filed an action before the Israeli Supreme Court seeking to secure coronavirus testing for 150,000 Palestinians living in overcrowded refugee camps in East Jerusalem. We also see, at the same time in Zimbabwe, an organisation called the Zimbabwe Association for Doctors for Human Rights, bringing litigation seeking to compel the authorities urgently to provide PPE, that's personal protective equipment, for medical practitioners. The fourth area that we see work being done across the world and globally is with regards to the position. It's focused on the position, the special risks faced by particular vulnerable groups. And we see, to give some examples, safeguarding prisoners in the US, we see constitutional actions being brought there around cruel and unusual punishment and other constitutional safeguards. In Australia, we've seen courts in Victoria finding that the government prima facie breached its duty of care to prisoners amid the COVID-19 pandemic and ordered an inquiry to be carried out. And we also see cases being brought in relation to immigration detention and other forms of institutional care. But the key thing is that this group of cases are very much focused on groups that are owed a special obligation by the state, whether because of the particular characteristics of that group, their particular social vulnerability, or because they are in state care or detention. Now, I want to move on to the challenges. The second key thing I want to talk about, the challenges faced by those bringing strategic litigation. First of all, there's a capacity issue, right? And this is evident in two key ways, I think, at this point. First of all, we see a capacity issue in terms of lawyers trying to bring human rights law to bear on new issues, right? So, for instance, contact track and tracing acts, digital exclusion in the context of school closures, and the need for PPE in private sector run care homes, okay? Old human rights law frameworks, very new issues, or issues that are suddenly receiving attention from lawyers that weren't receiving attention before. The second place that we see a capacity gap is where we see courts trying to deal with new COVID-19 related manifestations of long-standing structural issues. Okay, so what do I mean by this? So, for instance, where we see lawyers challenging disability discrimination, which is compounded in the context of lockdown or shelter-at-home measures. Okay, gender discrimination, which is made manifest in the context of job layoffs and furlough arrangements, which we're seeing in many countries in the context of COVID-19. And finally, I would argue the old classic, the deployment of emergency powers against societally unpopular minorities. Okay, and we're seeing lawyers having to be highly innovative in terms of legal argumentation. And we see them drawing on a wide range of domestic and international sources. And this is true even of jurisdictions where there's historically reluctance on the parts of courts to hear, and hence litigators to use, arguments based in comparative or international law. So it's interesting, we're seeing new tools being brought before the courts. The capacity issue, of course, isn't just about legal argumentation. It also covers evidentiary issues that are central to establishing human rights violations in the context of COVID-19. Crucially, if we think about lawyers, and particularly lawyers who may not have strong partnerships with, say, academic or research institutions, they aren't always able to access or even to identify the evidence that is needed to support their arguments. So, for instance, evidence on public health research or on the impacts of social policy or on the legal or factual situation in other jurisdictions. There's a clear gap here when it comes to evidence needed to support the claims being made. And of course, all of this, focusing on what lawyers are trying to do is before we get to the big, huge challenge that's posed to this kind of litigation in terms of access to justice and the operation of courts in the current situation. Okay, and we look at, say, work that's been done by the International Commission of Jurists and others focusing on this. We see court closures. We see the suspension of cases that are deemed non-urgent. We see cases being postponed. And we crucially see changes in the modality of hearings. For instance, the move to video conferencing for court hearings and client engagement. And I think the key thing to note is that all of these changes have massive implications for access to justice and to that of the most socially vulnerable in particular. And so it isn't surprising that we see strategic litigation organizations like HRLN in India lobbying for the flexibilization of procedural requirements necessary to promote access to justice during lockdown. Okay, so interestingly, we see it's not just that access to justice issues are being challenged through litigation, they're also being challenged politically by the same organizations who plan to bring litigation. Now, I'm conscious that my time is pretty much up, and I want to finish very quickly by trying to pull this together and trying to speak briefly about the crisis context. Now, many academics, including myself, have worked extensively on the role of litigation and the courts in times of crisis. And of course, advocates as well. Excuse me, I make it sound as if academia is the only place where this stuff is going on, which is of course not true at all. Now, the most prominent bodies of work, in English at least, tend to focus on security or terrorism, emergency crisis situations, and also more recently on the crisis context created by the financial and economic crises that kicked off in 2007, 2008. Now, I think it's important to note first and foremost, and it's a bit of a no-brainer, that human rights litigation in a time of crisis is rarely easy, okay? And it's particularly challenging in a public health emergency, which can serve as the basis for a very wide-ranging set of limitations and restrictions on rights. People are scared, people feel vulnerable, and in a health crisis, pretty much everyone feels vulnerable, and that makes them, I would argue, one can argue, and there is research on this, more accepting of limitations on rights, and particularly on the limitations of rights of others. So that's the context the backdrop against which much of this litigation is being taken. And crucially, from the perspective of strategic litigation, a public health crisis can contribute to a general mood of judicial deference in the spirit of state knows best, right? And hence the state should be accorded a very wide range of discretion in this emergency context. And this is, I would argue, exacerbated, particularly in the public health crisis context, this tendency towards judicial deference, because often the measures needed to address public health crises involve judgments premised on scientific and public health information that doesn't generally fall within the areas of expertise or the judging comfort zones for judges. And I think, just to conclude, that drawing on the experience of the financial and economic crises in the early 2000s, it's worth noting that looking back at those crises and the role of litigation in the courts, there ultimately is no clear-cut answer as to whether courts served as a counter-hegemonic force in relation to the crises, the economic policies that caused them, and the measures that were introduced in their wake. Okay, the role and the approaches of courts when it came to human rights litigation varied from court to court, from jurisdiction to jurisdiction, and crucially, over time. And it very much remains to be seen whether that will be our conclusion about the court's role and the role of litigation in the context of COVID-19. I leave it there. Thank you.
Thank you, Eva. Thank you for that global tour of litigation and the difficulties of using law and the courts to consider the challenges that are being posed to human rights through this pandemic. Now we're going to move swiftly on to our next speaker and our final speaker, Professor Robert McCorkdale. Now, Robert is Professor of International Law and Human Rights at the University of Nottingham. He's also a barrister and mediator at Brickcourt Chambers in London and a founder of Inclusive Law, a business and human rights consultancy. He's worked with governments, companies, civil society and international organisations around the world in relation to corporate responsibility and accountability for human rights and environmental impacts. Now, most recently, he was co-author of a report which prompted the European Commission to announce that they would introduce regulation next year on mandatory human rights due diligence requirements on companies. Now, Robert is going to talk to us today about the key human rights issues that arise in the business and human rights context. That is, how corporations have contributed or even caused human rights violations when responding to COVID-19. What we tend to do is we often focus on governmental responses to COVID, but we shouldn't forget the massive impact that corporations have on our lives. And I'm going to hand over to Robert to take us through the supply chains of subsidiaries, how global corporations have affected the enjoyment of the variety of our rights, and what human rights law can do about this.
Thank you, Sandra, for that excellent and very intriguing introduction. The context is, of course, COVID-19 has caused significant impacts around the world. And these include impacts on corporations and on the people who work for them, as well as down their supply chain and, of course, the people who work there. And in their responses to COVID-19, corporations have acted in ways which have caused, contributed to, or have been directly linked with significant adverse impacts on human rights worldwide. I'm going to share my screen for a moment to just give you some of the media reports that there are currently to show just how this is a kind of an area where it is very much one that often isn't in the public gaze, but in many ways is going on at a significant extent. And these are just a very small selection within the last few days of very different forms of reporting. What we see here are decisions by transnational corporations which have led to complete loss of employment down their supply chains, and in communities which have no government furlough, no financial support easily accessible, no access to healthcare, or their healthcare access was solely dependent on them having a job, no access to social security, and often then no shelter, and forced to walk for miles perhaps to where they might find some family support. Decisions that have been uncaring of the actual supply chain, which is providing protective equipment for those who are maybe in the global north, but with significant consequences for those who are making this equipment who don't have any of these protective equipment themselves. And decisions that mean that COVID-19 is spread and that human rights impacts will increase. So what does that mean in terms of where we take this? Well, all these actions have human rights impacts, and in particular impacts on women, on disabled persons, on migrant workers, and those in the informal economy. This also meant that even in economically wealthy countries, there is no personal protective equipment for carers in the public or private sector, as Aoife has already mentioned, and people die as a result, both carers and the elderly and vulnerable people. Now, these actions by corporations could be seen as just, well, an unfortunate result of the globalised market, bad luck. Yet they have significant and long-term consequences for both a sustainable and resilient global recovery, and importantly for human rights, for people in their daily lives. So what has human rights got to do about it? Well, traditionally, only a state could breach international human rights law, as the human rights treaties place legal obligations on the state alone. This has meant that even when a corporation causes direct harm, such as polluting the land or the sea or the air, with consequences for the human rights of those affected, it's only the state against which a human rights claim can be brought to an international human rights body by the individuals or groups affected. And there have been some claims like that. And now, much of this approach is replicated in domestic human rights legislation, as these are usually only directed at state actions, though there can be some specific human rights legislation for which corporations would also have to comply, such as for discrimination practices. Even then, applying these laws can be very difficult when a corporation is a transnational one, with subsidiaries and locations all around the world. And this can raise tensions, of course, under a public international base between countries where one government does not want another country interfering, as they would say, in a corporation which is incorporated in that first country. Now, this is despite the fact that, as Sangeeta mentioned, the reality for many, many people in the world is it is the corporation which more directly affects their lives, such as who they work for, who they sell to, who they buy from, who maybe owns their land, who they may get healthcare from, and from whom they may obtain water. This is also despite the core idea of human rights being about protecting people against oppression from power. And that power is not just political power, so it's not just about the state. It can also be economic power, as well as social and cultural power, and even power within the private lives in which we live. So more recently, there's been an increasing acceptance that corporations have some degree of responsibility for causing or contributing or being directly linked to adverse human rights impacts. This is seen in the development of some international documents, such as the United Nations Guiding Principles on Business and Human Rights, the OECD guidelines on multinational enterprises, and the International Labour Organization Tripartite Declaration of Principles Concerning Multilateral Enterprises and Social Policy. Now, some of this might be considered as just soft law and not yet directly applied, but it's moving beyond that. So, for example, in the last few years, France has passed legislation called the French Duty of Vigilance Act, and the Netherlands passed the Child Labour Due Diligence Act, which placed direct obligations on corporations to undertake actions to reduce their human rights impacts. And there have also been some innovative legal actions before domestic courts against, for example, parent companies, such as a recent United Kingdom Supreme Court case called Vedanta and Mangawi, in which I had a very small role, where a UK parent company was held to have a duty of care for a Zambian subsidiary whose copper mine and the overflow from the copper mine caused massive damage and harm to the local community. Indeed, as Sangeeta mentioned, just a few weeks ago, the European Commission announced that it would create regulations requiring corporations to conduct human rights due diligence, or else the corporation could be held accountable for their actions which cause, contribute to, or are directly linked with human rights impacts. And this is announced by the Justice Commissioner and then confirmed by the Trade Commissioner just on Tuesday. So very much we see that there is this development. And also what's interesting in this, that what this requires, this development of what's called human rights due diligence, is that corporations must assess their human rights impacts, integrate their policies and processes into all their operations, and track their outcomes and review them and then communicate what they're doing about preventing human rights impacts. And if these human rights impacts do occur, they must mitigate or remediate them. Now, interestingly, as Sangeeta mentioned, this decision taken by the European Commission unusually directly referred to a study in which I was a co-author. Fortunately, there were many other better academics than I involved, which recommended this. And so it is interesting how the work of people in the human rights law centre can have an impact on what then happens and develops in this area. Now, the other thing is that, oddly enough, many of these developments and regulation are supported by corporations themselves. Those corporations which place their priorities on the protection of human rights, on social values, and who act on it, want to ensure that all corporations do this. In fact, the Australian Modern Slavery Act was pushed very quickly through legislation because there was significant corporate responsibility for it. Why do they wish to take it? Some of it is purely because they recognise this is what should be done. Sometimes it's because they see a competitive disadvantage if they are doing it and other corporations aren't, and more broadly for the social and environmental good. So clarity of regulation is not just a civil society demand. Now, this background hopefully explains why so few actions during COVID-19 by corporations who have had human rights impact have led to government responses or litigation. But this may change, as seen in the Danish government response not to allow government financial support for corporations registered in tax havens. And other governments might limit, for example, public procurement access to those corporations which can show they have conducted human rights due diligence. So just a final couple of points. Aoife spoke about strategic litigation against government due to the COVID actions. It could also be litigation against corporations where they have not acted, for example, to quickly provide PPE to their care workers, to parent companies which do not act to reduce the human rights impacts of their subsidiaries, or where they cancelled orders already produced in their supply chains and are not paying for them. But alternatively, this could be a time when the financial economy becomes so important that social and environmental issues, such as climate change, get overlooked. Yet COVID-19 has highlighted the position that corporate activity worldwide does impact human rights. And the hope is that this could help to transform the legal accountability of corporations for human rights and environmental impacts in the future. So there could be an opportunity within this as well as a challenge. So that's all I wish to say at the moment. Thank you.
Thank you, Rob. That was a remarkable exposition on businesses, human rights, and what we need to do going forward. Well, I mean, we've had 3 really stimulating talks, and a number of questions have come through privately to me. I've now just realised I've opened up the chat, so hopefully we can see a few more questions coming up. But I think we'll give Robert a moment, perhaps, to have a drink of water, and perhaps dive right in with a question, and it's actually a series of questions for Marco. So Marco, if you brace yourself, and in essence, the questioner is asking, what do you think states should practically do to counter misinformation whilst upholding freedom of expression? So, what should promoting good information look like? And then I suppose a further follow-up question that's coming through is, do you think that there are any regulatory options available besides criminal law? So what about the possibility of addressing online artificial intelligence powered techniques that make misinformation viral, such as targeting and profiling, and regulating them or restricting them, especially during the pandemic or on a health-based on a health basis? Okay, Marco.
Excellent. I mean, that's a whole series of different big issues. So let me start sort of with the smaller, easier points first, and then we'll progress to the more controversial ones. First, as for criminal laws combating misinformation, I think states need to be exceptionally careful with these because on the one hand, they have an enormous chilling effect on protected speech. And on the other hand, they are unlikely to be very helpful in actually curbing misinformation. Now, why is this? That's because most misinformation is actually being spread innocently, as I explained in my presentation. So when you get a text from your mother saying, oh my God, I just saw this news item on Facebook about whatever garlic remedy that, helps COVID, you get that message from a person who wants to help you, not harm you. And you cannot subject a person who spreads misinformation innocently to criminal punishment. It would be wholly disproportionate to do that. So the only type of criminal law that could be lawful under human rights law is a very precise, narrowly tailored criminal law that effectively targeted the deliberate spreading of lies that specifically causes some grievous harms to human life or health. So that's the only type of criminal law that I would see that could survive the necessity proportionality analysis under international human rights law, and that would not, at least not as written, unduly restrict the freedom of expression. There is one country that has adopted such a narrowly tailored law that I'm aware of, that's South Africa. And they've done it through sort of an emergency measure now during COVID. But I don't know how actually it's been applied in practice. I mean, simply I have not been able to see information about the law as applied as opposed to the law as written. There are many, many states that have adopted or are reusing laws that are far more broad, far more vague, that do not impose any mens rea requirements at all, that, for example, simply punish the spreading of rumors without defining what these are, that punish the spreading of any kind of information that goes official government advice, etc. So those types of criminal laws are never going to satisfy the necessity proportionality test under human rights law. And in fact, in most cases, have an illegitimate purpose behind them. The purpose behind them is not actually to protect human health. The purpose behind them is to protect the government from criticism or to preserve the regime. And that type of law, which has that type of a legitimate purpose behind it, no matter how well written, is actually unlawful because it does not serve a legitimate aim. So criminal law is not the solution to the infodemic. It is an epiphenomenon. It is something you may want to have or not, but the amount of people who are really going to be legitimately prosecutable under such a law will be very, very small indeed. So that brings us to the sort of second part of the question, what can states really do to promote accurate information? Well, we don't have to reinvent the wheel here. Epidemiologists have had a lot of experience on how you do effective public health communications during an epidemic. The US Centers for Disease Control, the CDC, has a manual on how you do effective communications for public health during a pandemic or an epidemic. For example, you put forward an expert who can build trust in the public. The expert always has to start any kind of communication by sharing what their basic message is and reiterate that basic message repeatedly. You must remove highly political polarizing actors from that type of communication. So everything basically that the Trump administration has been doing is what you should not be doing. Right? So that's how one should promote accurate information. One should, the state should. Somebody's not muted, and that's very noisy. So the state should promote, should have websites, other facilities, etc., that allow the members of the public access to accurate information. The state should certainly not, as India, for example, has done in Kashmir, shut down the internet or slow down the internet so as to inhibit both doctors and members of the public from accessing accurate information. The big problem, though, is that all your promotion efforts might not work once people have really internalized bad information. It's very difficult to dissuade, for example, a committed anti-vaxxer. It's really difficult to dissuade them from those views that are not, scientifically corroborated that vaccines cause some ill effects. Once they've gone a certain point, there's really nothing you can do with a persuasion effort. And so I do agree in that regard that there's a huge amount of regulatory role that states and private companies, the digital platforms like Facebook, Twitter, etc., over which a lot of this misinformation is being spread, that there's a huge role that they have to play in moderating content so as to curb, to some extent at least, the spread of viral misinformation. And if you see what the digital platforms have been doing, they have been far more active in this context than, say, with regard to political disinformation in electoral context before. However, even that might not be enough. And the really bad thing is that these digital platforms are making all of these decisions for themselves, and that some key questions on how you balance the freedom of expression and the public interest and the need to protect people from misinformation are being made by corporate profit-driven actors rather than by states which enjoy democratic legitimacy in their society, where those types of decisions will be made to proper, with proper scrutiny and so on. So that's, I think, the big issue, is how you strike some of these regulatory decisions in democratic societies.
Okay.
I answered everything. I don't.
we need to come back to you. Thank you, Marco. And we've actually had a sudden flurry of questions come through. So I think I'm going to skip. I think perhaps to actually to Aoife, if that's okay. I'm sorry. I just jumped in with it. The questioner would just like to invite reflection on the implications of delays in decision making on access to justice and effective remedies. So referring to contexts such as the asylum systems, national referral mechanism for victims of modern slavery, etc., etc. So maybe just a quick comment about delays and impact on access to justice.
I mean, there's, it's such a cliche, justice delayed is justice denied, right? And I mean, it's particularly true when you're dealing with people who are in particularly, precarious situations. For instance, in the criminal justice system, where you may be in an overcrowded prison, away from your family, awaiting a long postponed case, or in the context of, for instance, immigration detention, where you're waiting for a decision on your case. It's hard. I mean, essentially, it's hard to provide a particular overview or comment on it. What I would note is that obviously particular groups have particular concerns when it comes to access to justice, and particular rights issues have make a speedy resolution of problems around those rights issues particularly important. Okay, so there are some groups, whether it be children, people with disabilities, who generally there's an understanding that their rights require special priority to be given to complaints involving their rights in terms of international human rights law, and often in terms of national procedure. But more generally, even beyond those groups, there are particular situations where it's clear that the delays that we're seeing with regards to different proceedings, hearings, even the ability of people to speak to their clients, I'm talking about a criminal context, but also other detention or institutional contexts, are hugely damaging, both in the short term and in the long term. And it's hard to see how those short-term impacts won't have long-term impacts, even when the courts do reopen and things get back to normal. That is particularly so given the backlog that courts will be facing, and the fact that prioritization is likely to continue for the foreseeable period after the courts reopen at full pelt anyway.
Thank you, Aoife. I'm going to give both of you a break for a second and shift to Robert. We've had a couple of questions that relate to due diligence obligations. So one in particular, can we infer or are there any existing legal bases that would trigger due diligence obligations on states towards corporations established in third countries. But also a further sort of follow-up question from somebody else. To what extent do you think the British government will commit to mandatory human rights due diligence for companies post-COVID? So,
thank you for those two great questions. Starting point about human rights due diligence is it is an obligation initially on states. There's case law such as the Velasquez-Rodriguez case against Honduras in the Inter-American Court of Human Rights, which made it clear that a state has an obligation in relation to any abuses which happen within their territory, even if it's caused by a corporation. And another example would be a case against Nigeria by the African Commission on Humans and People's Rights, or by the Centre for Economic and Social Rights against Nigeria, which was all about the actions which Shell had done in Nigeria, and Nigeria was found at fault for that. So it certainly is an action, and that's a good example, I think, of the question about what can a state do when it's when it's a company from a third state, as Shell was. Well, they still have an obligation in that regard. So that, oddly enough, the obligation does exist in relation to corporate action, but it's also one where states have been generally reluctant to do so. However, saying that, some states have introduced regulation which affects corporations in third states. For example, the UK's Modern Slavery Act, although it has basically no enforcement provisions, applies to all companies operating in the UK. And similarly, the Bribery Act, which does have criminal enforcement, relates to corporations in the UK dealing with corporations elsewhere. So I guess it is possible. I mean, in particular, I would hope that public procurement would be a way forward of this, but governments tend to be so far reluctant to do that, even if there are consequent reputational consequences for both the government and the company. So what that then means, do you think, you asked the question about whether or not there might be mandatory human rights due diligence in the UK. I was on a special advisor in the Joint Parliamentary Committee on Human Rights who investigated this a few years ago, and their recommendation was there should be. But of course, governments have different priorities. Sadly enough, I can't see this being a priority for the UK government. And yet, of course, it came in France, it came in the Netherlands, Finland is actively looking at this, Germany's produced a draft. So I think there is a possibility in the UK, but I don't think it's at the moment high on the agenda. Thank you.
Thank you, Robert. I'm actually just going to throw out a question for all the panellists, which is, and perhaps you could keep your answers relatively brief, but how do we decide what human rights take precedence right now when there are conflicts between them? It's the classic question. For example, rights relating to freedom versus those relating to health and life, especially considering the longer-term economic impacts of lockdowns on human rights. So if I could invite all of you to perhaps give your conflicting opinions on this.
Can I start? I think it probably makes sense as someone who works in economic and social rights, where we're frequently told about how certain rights have to be prioritised over other rights, and there are all sorts of reasons for that. My answer is very short. Almost every situation requires balancing of rights and complex decision-making around rights when it comes to law and policy. Human rights law litigation is there to sort out kind of the most egregious manifestations, often after the fact. But the fact that you are going to potentially have conflict of rights or the need to balance rights doesn't mean that you can't use a human rights frame to analyse a situation or to suggest a human rights-based solution to a problem. It's just, that's part of the nature of the game that you're playing. Human rights, balance is part of everyone's work in the day-to-day. It may seem more urgent in the context of crisis, but in fact, it's something that's there all the time.
Marco?
What Aoife said.
I'm going to add to what Aoife said, though I completely agree. I think sometimes this question comes out of an idea that there are sort of certain rights which have a hierarchy over others. That's, I think, an understandable starting point, but actually it's not the right starting point. The starting point for which right will have the most importance to an individual will depend on their situation. So for some, access to education might be important. For some, just simply having shelter or water. And for others, it might be freedom of expression. So it's going to vary enormously within a particular situation. So when it comes to litigation, of course, these things can get quite a tough decision to be made. But otherwise, I think the way that Aoife expressed it, I would completely agree with.
Thank you. Thank you all. We've got a few more questions, and I think we've got a little bit of time. So I'm just going to pick a couple. So Marco, and actually it's about contours of obligations, really. So what are the contours of the positive obligation for states in relation to misinformation? India, for instance, has been arresting individuals who shared fake news they received via WhatsApp, despite not being the originators of such misinformation. Is this necessarily what a state should be doing instead of focusing on spreading credible information and debunking misinformation? But also, sort of a further follow-up question that's arisen is a state misinforming if they hide information?
I think that last point is very interesting, and the answer must be surely yes. Hiding a key piece of information can be as manipulative as distorting information that's already out there. The question exactly is how that would work in the pandemic context. I can't think of a specific example right now, but like hiding, for example, the numbers of people who are dying, hiding the numbers of people who are infecting, hiding the low levels, for example, of PPE that are available in hospitals. That type of misinformation, which when you that type of silence or hiding of info, that when you aggregate it, actually substantively contributes to risks to public health, can certainly violate the state's obligation to promote accurate information under the right to health, the right to life, and the freedom of speech. When it comes to the India example, so obviously so clearly what states must do in terms of positive obligations is a narrower set of things than what they're permitted to do in terms of limitations to human rights. And human rights law does not impose any kind of requirement of uniformity. Different societies will have different needs. In some societies, the virulence, if you will, of the infodemic might be bigger than in others, and somewhat more proactive measures might be necessary. But what I can definitely say is that the criminal prosecution of people who are innocently spreading misinformation is unjustified, and that there are other things that the state can do that can have a much more positive effect on curbing the effects of misinformation than the criminal prosecution of effectively innocent people who are not trying to deliberately lie or mislead or cause harms to public health.
Okay. Thank you, Marco. I've got a sort of cluster of questions, I think, for Aoife, which sort of start with, are there any particular cases on disability discrimination and COVID that you're aware of? But sort of shifting on, so more broadly speaking, there's a question about sort of increased non-compliance with international judgments due to governments using COVID-19 as a pretext to returning to discriminatory practices. So the question is actually asking about sort of the response to DH versus Czech Republic and the Roma children. And are there sort of things that the international community can do to prevent that kind of slip back? And I suppose sort of following on from that, a further kind of question about and what is going on in terms of international litigation. So I'm sorry, I've thrust a whole load on you there, Aoife. Let's see what you can do with that.
Not at all. I can see a link. With regards to disability discrimination, there are an awful lot of cases. I would say if you even look in the UK alone and you look at the ones taken in the context of the Human Rights Act and equality legislation, you'll find ample jurisprudence there. Or in fact, what's interesting is that many of the cases around disability discrimination are so extreme that in the UK context, it's enough to send a letter threatening legal action in order to see a change to the regulation. So it's not necessarily that the actions around disability discrimination in the UK have had to even go to court. It's been enough to say, we're going to bring you to court in order to amend the regulation. Or to get the government to amend the regulation. I'm very happy to answer that question by email, but I think it's so wide-ranging. It would be good for me to know and what kind of decisions and which aspects of disability and which aspects of human rights interference you'd be interested in hearing more about. So please do feel free, and indeed everyone, feel free to follow up with the speakers by email. With regards to the DH in the Czech Republic case, absolutely. I mean, we're seeing in particular with regards to Roma, and I'm going to talk particularly about the Council of Europe. I'm on a body called the European Committee of Social Rights. The DH in the Czech Republic is a European Court of Human Rights case, but there's clear awareness on the part of the different Council of Europe bodies, both quasi-judicial, judicial, and ones focused more on the promotion of human rights. That there are definitely, we are seeing government using COVID-19 in some instances explicitly, in other cases implicitly, as an excuse to move backwards in terms of rights enjoyment. And in some instances, for instance, with regards to the question of desegregated education, it's very clear that this is further entrenching long-term discrimination against societally unpopular minorities, and we're seeing that Roma in particular in Council of Europe states have been the subject of very negative treatment, special lockdown, lack of provision in the of services and goods in the lockdown that other groups benefit from, and that's something that people are very aware of. What can the international community do? The international community has to be aware of it. There's obviously international bodies like the European Committee of Social Rights, but the UN Committee on Economic, Social and Cultural Rights will look at these issues in the context of their reporting. There's also the complaints mechanisms. But what I would flag at this point, many of my comments related to litigation at the domestic level. That's not surprising given that most international complaints mechanisms, international and regional, require exhaustion of domestic remedies, which means that you have to go through some sort of a process or an effort, at least at a domestic level, even if you feel it's completely futile, in order for it to be something that is considered by the international or the regional human rights body. An exception to that requirement of exhaustion of domestic remedies is the European Committee of Social Rights. I obviously can't say anything about the complaints we're receiving or will be looking at, but it is, I think, it would be unsurprising if we were one of the earliest bodies to deal with human rights related COVID-19 complaints on the basis that we don't require exhaustion of domestic remedies for a complaint to be brought.
Thank you, Aoife. And I'm going to round up, I think, with a final sort of couple of linked questions for Robert. So, firstly, I think perhaps the context of the question is required. So following Marco's response and in part linked to Robert's presentation, this is a question really about the key role played by digital platforms in regulating online content. And would it be better to focus on the ways, channels and techniques used to spread news online and on the business model of digital advertising that makes misinformation also particularly lucrative for companies. So is there any possibility of addressing the business model of digital companies through national legislation or international human rights soft law instruments? But following on from that, a further question that's been asked is the role of the private sector being considered in litigation in relation to human rights issues? Is it already happening, I suppose, in litigation? Sorry, I've lost my moment there for a second. If I could hand over to you.
Thanks, Sangeeta. I'll deal with the first question, which is an interesting one, because it's a whole developing area about artificial intelligence and human rights and how they are linked. And one of the core areas, as you picked up in your question, is how do we engage with the various digital platforms in order to deal with human rights issues. Marco can speak to the specifics of misinformation and freedom of expression if he wishes to. I'll just pick up the broader issue about, well, can they be held responsible as a starting point? Part of the difficulty in this area is where are they located, because the developing area in this, the developing law in this area is about the notion of domicile, that it's not just where a company might be incorporated or registered. It can also be where its central place of business is or where its main headquarters might be. And so that is relevant perhaps for where the regulation may occur. But of course, in many instances, these are corporations operating worldwide, and that a decision by one state won't necessarily affect the broader operation. So it's an area which needs international reaction and regulation. However, that doesn't mean there's no action that a state can take. For example, many companies use artificial intelligence in their day-to-day activity. It could be in how they work with customers' preferences. You think about how often, if we're on a search, suddenly a drop-down will occur on something which we've searched for a little while before. They are taking our preferences all the time. And also can happen in recruitment, where a decision made based purely on data which is already determined in advance, a particular algorithm, might mean that somebody, for example, is excluded because they are not the desired criteria for that job, and that could be deeply discriminatory. So there's a range of levels for which I think these issues of artificial intelligence and to the digital platforms are relevant. And I would just say that all corporations of any size, of any kind, of any nature, in whatever sector, are subject to the soft law of the UN Guiding Principles on Business and Human Rights and the slightly less soft law of the OECD guidelines for multinational enterprises. And in fact, action can be taken under the OECD guidelines against companies before what are called national contact points. And so there is possibility, although there's no, in my view, particularly strong effectiveness in the decision-making, it can highlight issues in that area. In relation to your second question about the role of the private sector and litigation, there is some litigation. In fact, interesting enough, there was for a number of years litigation in the United States under what they called the Alien Tort Claims Act, which allowed a company to be a claim brought against them where they were involved in some human rights abuse, which was contrary to customary international law, such as torture. That's now went to the US Supreme Court and held that that was no longer possibly brought against a corporation unless they were effectively a US corporation. However, developments have occurred at a significant level around the world subsequently, particularly in Canada, the UK and the Netherlands, all of which show that there is quite an active litigation against private companies. There's a recent case by the Canadian Supreme Court called Nevson and Araya, which held that in this instance it was about use of forced labour in Eritrea, and the court held that customary international law could be held against a company. So quite an interesting development in the sense that allowing customary international law is not only an obligation in relation to states. There's a range of cases in the Netherlands which have also developed this area, and I mentioned one in my presentation about a case called Vedanta in the UK. So there are a range of different possibilities of litigation against companies in this area for human rights abuses. And I should just add that across much of continental Europe, there are also cases, particularly in France, which are often criminal cases, partly because the advantage of a criminal action, if you can persuade the prosecutor, is that then you can access the documents which are otherwise largely held in the hands of the corporation, which in a civil claim is much harder to do. But there aren't anywhere near the number of cases compared to the jurisdictions I mentioned. Thank you.
Thank you, Robert. We're pretty much at time, so that was a perfect sort of ending to today's discussion. We've gone so far. It feels like we've really addressed a number of issues that I'm not entirely convinced have really been discussed thoroughly elsewhere. So it's great to be able to bring this information and our thinking, I think, to the wider public. As I say, the Human Rights Law Centre is constantly working on this sort of stuff, and we want to work with you. We want to talk to people. We want to engage with you about your ideas, about our work. And so please do contact the centre. Please do get in touch. And thank you all for coming along and for your insightful and critical comments and questions. And finally, thank you to our speakers. You've all zoomed in very well and very capably. And thank you for sharing your expertise today. Okay, so stay well, stay safe, and take care. Thank you.
Thanks, everybody. Bye.
Thank you, Sangeeta and everyone.